from the land of the windy. She get cold in the summertime. They call it direct. Tat that on my chest. They know that it's that wherever I'm at. Gotta get that check on Mac.
So, Judge, if I may add on to that just briefly, essentially because the one portion of this case that I took on and actually
see what's going on with Melly, man.
Lots of money was put into training me on this very issue of these phones, right? So I know what they
My
would
boy
have
ready to
got
get
off
up
of
out of
this
there,
night
shut
phone.
it.
They would have got information regarding my emails. I'm assuming there's further emails warrants to my email accounts. I am concerned, going off what he says, that there's communications between my experts. Almost all my communications are on my emails with my experts, motions, depositions from other cases. So there will be further inquiry to that, and I think we're granted to that. But looking at the court's own order, you had, and I forget the name of the case, but the basis was saying that it's been, what, 14, 15 months at this point? There's no imminent arrest. So there, I read it as you're finding that there is no criminal investigation.
She can,
and that was the
wait,
basis of not letting us have the affidavit. The initial time was.
That's not correct. If this was
That's the judge that was
the statute, the state would have been right. I
having
just
secret
found
meetings
that
with them
there's
about
an
without
based on the
consulting with
particular
Melly
posture
lawyer,
of
ain't
this
it?
case, whatever it is that they got as a result of this,
He look
they
like
got
he
over
be
here,
on
so they
bullshit.
want
Look
to
at him.
charge you with something
He
or
look
arrest
like he
you.
be on
They're not
bullshit,
here
be trying
do
to
that. I'm not
cook a
gonna
nigga.
sit around and wait for them to make that decision. They obviously haven't made the decision. The statute says if there was an ongoing case, you wouldn't be entitled to any of it.
Okay, fair enough, Judge.
So I'm just complying with what the statute says.
May I speak?
Sure.
When we were here the first time on the case, I'm the one that brought it forward, the motion, and you asked me what my authority was. I had cited to the court the case of Rutledge versus State, 150 Southern 3rd, 830, 2014. You asked me what my specific authority was, and I said the 6th Amendment and the 14th Amendment. I'd like to read from Rutledge, if I might. At the risk of being redundant, we once again emphatically state that when a pretrial disclosure
We're getting it
of possible
emphatically
conflict
stated.
of interest is raised, the trial court must either conduct an inquiry to determine whether the asserted conflict of interest will impair the defendant's Sixth Amendment right or appoint separate counsel.
Yeah, that's what that money do. They end up
With
fighting
respect
for
to this
Melly though.
court,
They
Your
been fighting. They
Honor,
ain't
that's
stopped
your
fighting.
job,
They
is
gonna
to
keep
find out
fighting.
whether or not there's a conflict and for you to help in the investigation. We don't have the power. Without the court's help, we'll never know if there's a conflict until possibly it's too late. So you are the person that is supposed
Look
to
at the judge,
look
though. He-
into the matter for us.
I don't agree with you at all, sir.
I don't
Your
agree,
case says
man.
Mr. Demons is entitled to be told that there's an ongoing investigation. There is an ongoing investigation, and I told him that the last time I had a discussion with him directly. After that,
No.
Figueroa Sanabria completely controls. This is a death penalty case. He's a death penalty defendant. It's
This is
his
a death
decision.
penalty case. He's a
Yes,
death
it
penalty
says here, the
defendant.
trial
Shorty, he
court
and that
must
bitch
either
over mean
conduct
as
an
hell.
inquiry to
He
determine
and that bitch
whether
over mean as hell
the
trying to
asserted
cook Melly
conflict of
ass,
interest
boy.
will
Man,
impair
free
the
Melly,
defendant's
man.
Sixth Amendment right or appoint separate counsel.
Well, that's Mr. Demons' decision, and the last time you all got almost hysterical that you didn't even want me to
Man.
talk to him about it. You want me to talk to him about it today?
But
Look,
you
look
have
at how
not
they.
conducted any inquiry, with all due respect.
The inquiries with your client, sir.
No.
It's not my job to
The
investigate.
trial court must either conduct an inquiry.
Yeah, that's with Mr. Demons. That's the inquiry.
Well,
I can
and
tell him there's a conflict.
I can tell him there's a conflict.
The same law enforcement agency that,
Huh?
the same state attorney's office that's trying to impose the
wanna
death
come
penalty
here
on
with
him
me?
is
Come on.
conducting a criminal investigation
keep
against one of his
interrupting my
lawyers.
stream.
So I can save you all that trouble. There obviously is a conflict. Whether Mr. Demons wants this liberty to continue or all be continued, that's his decision.
Look,
But there's
now you
nothing
on
else I can
camera.
do about it. You all
You
conduct
see?
whatever investigation
Look.
you want.
Look at the computer
What
now.
did you want me to do, Mr. Anderson? You want to start
You see?
deposing witnesses?
There's Yaya on the computer.
Deposing witnesses have
Please
inquiries.
start deposing.
I want you to inquire of the state what evidence that they have of a conflict, so we know.
Yeah, I'm
in
watching them
fact,
trying to
if there's
cook
a
Melly.
Conflict or not.
The state says there's a conflict too. You
Well,
read their plea.
they say my client, they say my client's guilty, but he's entitled to a trial first.
They filed a motion that said I'm supposed to remove her. They think I get to decide who's Mr. Demons' lawyer is, not Mr. Demons. I couldn't agree with that. I couldn't disagree with that more. It's his decision.
I believe, as the court, you have
think
a
it's up to me then.
obligation to ferret out what the conflict is so that we can make an informed decision. Right now, we can make
Yeah,
no
that's a mean
decision.
judge.
Right now, we can file no motions because we don't know whether we're subject to the conflict at all. Right now, our hands are tied. It's up to the court. You're the gatekeeper for all. I'm imploring the court to find out what the nature of the conflict is so that we can advise our client. Right now, you're just saying to our client, hey, the state says there's a conflict, so you can get rid of your lawyer or keep your lawyer. That's not enough. That's not a Sixth Amendment protections.
Lay down.
You want him to make a decision in a vacuum. This is a murder case.
Sir, with all due respect, this isn't a vacuum. He can sit down with Miss Liberty, and you can sit down with Miss Liberty. She's well aware who she's emailed. She's well aware who she's called. She's well aware what's on these records. So talk to it's incumbent on you all to fully inform your client. That's not my job. That's your job.